Today in the newspaper, yesterday Supreme Court has given a very landmark judgment regarding right to abortion for single unmarried woman. So going through that, in 2019 there was a Parliament amended one act that is called MPTA, Medical and Pregnancy Termination Act 2021. There is one act called Medical Surrogacy Act. उसको तीन ये जो Surrogacy Act, Medical Termination of Pregnancy जो act है उसको जरूर पढ़े. Right from newspaper, whatever I have taught you, the theme. For example, we talked about many themes, right? You just also look into the newspaper, what the newspaper says. Fine? Sorry? Surrogacy Act and Medical Termination of Pregnancy Act, MPTA 2021. Right? If you see the American Supreme Court, that terminated the very long back in 1973. The Supreme Court in Roe versus Wade case, the American Supreme Court granted right to abortion for women. But recently, the American Supreme Court said that we cannot grant a nationwide law for abortion. Fine. So that's why right to abortion was in very actually discussion. So इसको जरूर पढ़े. American right to abortion के ऊपर जो भी debate है ना, right? And right to abortion comes under which article? Yeah, Article 21. You are right. Right to abortion comes under Article 21. Fine. तो ये सब थोड़ा सा पढ़ना चाहिए. फाइन. आज जो सुप्रीम कोर्ट का वर्डिक्ट आया है उसको अच्छे से पढ़े और उसको अपने करंट अफेयर के बुक में, नोटबुक में इंक्लूड करें या पॉलिटी के नोटबुक में इंक्लूड करें. फाइन. या यू मस्ट इंक्लूड इट. Now let me talk about fundamental this right to constitutional remedy. First you write. आइए. और है कोई आने वाला? आइए कम. राइट टू अबॉर्शन देखना है. मतलब एक तो आपको 1970 में आया था रॉय वर्सेस वेड, ये जो केस था अमेरिका में, ये वो देखना है. राइट. और राइट टू अबॉर्शन के ऊपर जो भी डिबेट है, right, either if you look at US Supreme Court has prohibited a nationwide right to abortion law. Then you have MPTA Act, Medical Pregnancy Termination Act 2021, which provides a right to abortion for women. Right. If you look at Indian law, right to abortion available in India since 1971. First time this act came in 1971, which allow women right to abortion within 20 weeks. ठीक है? 20 weeks, है ना? And this allowed 20 to 24 weeks. Right, and it is a broader in nature. The new law. Yesterday, Supreme Court came with a judgment, a landmark judgment, that even a single woman have right to abortion. Fine? Yeah. सब हर चीज में, मतलब फाइन. और फिर सरोगेसी एक्ट भी देखना है आपको. लिख लो ये सब एक्ट, न्यूज़पेपर से देखना है. अगर मैं ये एक्ट पढ़ाने लग गया फिर तो टाइम लग जाएगा बहुत. ये एक्ट देखना है आपको. The Medical Surrogacy Act, which which prohibited commercial surrogacy, right? commercial surrogacy is not allowed in India. What allowed in India? It is an ethical and altruistic surrogacy. If a couple, certified by the doctor, right, that see about her inability to produce child, then they can go for surrogacy. Got the idea? ये सब चीज 3-4 चीजें जरूर देखना. आज का जो रिपोर्ट है उसको लिखिएगा, आइदर करंट अफेयर के नोटबुक में लिखे या पॉलिटी के नोटबुक में लिखे. Because I told you that polity, any act of the government, you must notice. It may be legislature, it may be executive, and it may be the judiciary. और यार अभी तक तो पता नहीं चला मुझे, अभी तक EWS का तो आ गया है. तो UAPA के अंदर बैन किया, गवर्नमेंट है ना. Central government has under UAPA declared as a unlegal, unlawful organization. EWS, Supreme Court preserved actually validated 103rd Amendment Act. बोला कि ऐसे ही रहेगा, रिजर्वेशन मिलता रहेगा EWS को, 10% रिजर्वेशन will continue. Yeah. I was also thinking the Supreme Court will not validate 103rd Constitutional Amendment Act, which provides 10% reservation to EWS, but finally Supreme Court validated 103 Constitutional Amendment Act, which provides 10% reservation to the EWS. Anyway, वो बात राइट, ये सब जो चर्चा चलता रहता है वो सब थोड़ा नोट करते रहिएगा. राइट, जुडिशरी का जो भी related issue ho. Now come to the Article 32, which is right to constitutional remedies. First you write, it is a fundamental right which guarantees other rights provided by Part 3 of the Constitution. It is a fundamental right which guarantees other rights provided by the Part 3 of the Indian Constitution. Second point you write, Dr. Ambedkar described Article 32 as the heart and soul of the Indian Constitution. Dr. B.R. Ambedkar described Article 32 as the very soul and heart of the Constitution. Fine. Third, you write Article 32 is the basic structure of the Indian Constitution. Article 32 is the basic structure of the Indian Constitution. It means it cannot be amended. Supreme Court in L. Chandra Kumar versus Union of India case described it as basic structure. Supreme Court in L. Chandra Kumar versus Union of India case described it as a basic structure. Fine. The next point you write, fourth point, in order to protect fundamental right, the Supreme Court can issue writs. In order to protect fundamental rights, the Supreme Court can issue writs under Article 32. In order to protect fundamental rights, Supreme Court can issue writs under Article 32. Similarly, High Court can issue writs under Article 226 of the Constitution. Similarly, High Court can issue writs under Article 226 of the Constitution. The writ's jurisdiction of the High Court is larger than the Supreme Court. The writ's jurisdiction of the High Court is larger than the Supreme Court. Okay. The Supreme Court, next point, the Supreme Court can issue writs under Article 32. The Supreme Court can issue writs under Article 32 when fundamental rights is violated. When fundamental rights is violated. Whereas the High Court can issue writs under Article 226 whereas High Court can issue writs under Article 226 to protect fundamental right as well as legal right. Got the idea? So High Court can issue writs also for the enforcement of legal rights, but the Supreme Court can only issue writs only for the enforcement of fundamental right. Sorry? Legal right, no. Supreme Court cannot issue writs in order to enforce legal rights. So, of course, if you look at the Indian judiciary, it is hierarchical, right? It's like hierarchical. First Supreme Court, then High Court, then District Court, then Subordinate Court, right? But the Constitution gives more power to the High Court in case of writs jurisdiction. The Supreme Court can issue writs, otherwise सारे legal के केस में वहीं पहुंच जाएंगे. कहां पर? Supreme Court में, right? But Supreme Court is is a supreme, na? It should look only few, not all the cases, right? So here the range, the range of issuing writs for the High Court is larger, right? It can issue writs for the constitutional safeguard and for the legal safeguard, but the Supreme Court can only issue for the protection of fundamental right. Can SC stop any SC raid? Writs? Nahi. Dekho, let me tell you one more thing. of course we have integrated integrated judiciary, right? And it is hierarchical one. Supreme Court is High Court is subordinate to the Supreme Court, right? But in many cases, High Court is equal than Supreme Court. For example, power of judicial review. Power of judicial review. So मान लीजिए कि if center violates constitution, High Court has also right to issue writs to the Supreme Court, to the center. It's not that Supreme Court will issue writs to the center or direction to the center. High courts can also issue direction to the center state, central government. Right, one more case. Can SC stop any SC writs? No. Amber, in case of issuing writs jurisdiction, Supreme Court and High Court has equal power. So High Court ने कुछ कह दिया, Supreme Court can review it, can change the decision, but cannot nullify it immediately. Fine. Now, one line you should write. Article 226 must be concurrent with Article 226 must be concurrent with Article 226 must be concurrent with the jurisdiction of the Supreme Court. इसका क्या मतलब है? The High Court writ jurisdiction must be concurrent with the Supreme Court writ jurisdiction. ऐसा नहीं कि ये इसके beyond में चला जा सकता है, ये कभी नहीं हो सकता. High Court jurisdiction cannot go beyond the Supreme Court jurisdiction. Making sense? नहीं. The High Court have writ issue jurisdiction under Article 226. Supreme Court has under Article 32, right? So High Court jurisdiction should be always within the limit of Supreme Court jurisdiction. It cannot give some jurisdiction, which may violate the Supreme Court judgment. But the idea, High Court should not give any judgment that may violate the Supreme Court judgment. It will give all the judgment within the ambit of its own jurisdiction, right? Or within the Supreme Court verdict. So when, for example, let me give you a case मैंने बताया था आपको, right to attempt to suicide, right? So High Court can give some, can decriminalize the any law. For example, IPC 377, it was decriminalized by High Court, but again it was decriminalized by the Supreme Court. Now High Court cannot take another position. When it is decriminalized by the Supreme Court, it is decriminalized. Once Supreme Court has given verdict, High Court cannot review. Only Supreme Court can review its own decision under Article 137. And Supreme is a Supreme. Got the idea? But one can, ठीक है? यहीं तक. SC have power to overrule SC judgment. Sir, SC does not have power to overrule the Supreme Court judgment. Never ever. No, he's asking HC. HC means High Court. SC has no power. The High Court has no power to overrule the Supreme Court. But Supreme Court has power to overrule the High Court. Fine. Nitin? That is. Fine. ठीक है. These are the basic structure. Article 32 and Article 226 both are basic structure. ये लिखा क्या, ये लास्ट पॉइंट लिख लो. Fifth point, you write Article 32 and Article 226. Both are basic structure of the Constitution. Article 226, Article 32, both are basic structure of the Constitution. Fine. Now come to Article 32. What does it say? Right, Article 32, Clause 1 empowers citizen to move Supreme Court. Article 32, Clause 1 empowers citizen to move Supreme Court by appropriate proceedings. For the enforcement of fundamental right. Article 32, Clause 1 empowers citizen to move Supreme Court by appropriate proceedings for the enforcement of fundamental rights. Sir, the last point repeat करना है. अच्छा, इससे पहले बोला था मैंने हर्ष, Article 32 and Article 226 both are basic structure. Yeah. Then after that, I have talked about this point. That's Article 32, Clause 1 empowers citizen to move Supreme Court, to Supreme Court by appropriate proceeding for the enforcement of fundamental rights. Next point, Article 32, Clause 2. Article 32, Clause 2 says that the SC shall have power, the Supreme Court shall have power to issue directions, orders, or writs, including in nature of habeas corpus, mandamus, prohibition, quo warranto, चार हो गया, एक और है, and certiorari. Yeah, certiorari, which may be appropriate. appropriate. Now, Article 32, Clause 2 says that Supreme Court shall have power to issue directions, right, orders or writs, including habeas corpus, mandamus, prohibition, quo warranto, and certiorari. Right? 5 है. Article 32, Clause 3 argues Achira, it is 2 to 6. Yeah. Article 32, Clause 3 हो गया ना? Clause 3 होना है. Yeah. Clause 3 says that the Parliament may, by law, empowers any other court to exercise within the local limits of jurisdiction. Article 32, Clause 3 says that the Parliament may, by the law, empowers any other court to exercise it within the local limits of jurisdiction. Right? Either all or any writs exercised by the Supreme Court. By the Supreme Court. So it's a very important point. The Parliament can empower any local court to issue writs within its own jurisdiction. ऐसा नहीं कि local court एर्नाकुलम पूरा केरला के लिए writs jurisdiction करेगी, नहीं. Within its own local jurisdiction, in every state there is a district, and in the district there is a local court. It's called district court. So this district court can issue writs if the Parliament empowers it. Making sense? How these writs used particularly, sir? There are, a lawyer can tell you better. Right? Basically, you have to approach to the court, right? And lawyer will tell you the proceedings, what are the proceedings to file, right? And then court can hear it immediately, right? And any rights which is being violated, right, encroached upon by the state, which right? Fundamental right. One can approach to the court. Status quo means उसको maintain करना जैसे को तैसा. Maintain status quo means अगर मैं खड़ा हूं तो खड़ा रहूंगा. I'm a status. अगर मैं बैठ गया तो बदल गया. It's a revolution. Fine. Writs means issue directions, orders. Bisijyoti, writs. The word writs is used instead of direction. You can say order, ओके, हाँ, लीगल ऑर्डर जो, फाइन. Now next point you write Article 32 clause 4. Article 32 clause 4 says that rights guaranteed by this article shall not be suspended. Rights guaranteed by this article shall not be suspended except rights guaranteed by this article shall not be suspended except as otherwise provided by this Constitution. Except as otherwise provided by this Constitution. Got the idea? It means Article 32 cannot be suspended. नेशनल इमरजेंसी में सस्पेंड नहीं होता है, इंप्लीमेंटेशन नहीं होता है. यानी कि आप हाई कोर्ट और सुप्रीम कोर्ट नहीं जा सकते अगर फंडामेंटल राइट वायलेट होता है तो, राइट? हाँ, स्टेटस को मेंटेन रहता है, you cannot go, but Article 21 and 20 cannot be violated. In the case of Article 20, violation of Article 20 and 21, one can go direct approach to the High Court or the Supreme Court. Article 32 clause 4 says that rights guaranteed by this article shall not be suspended except otherwise, except as otherwise provided by this Constitution. It means during national emergency, your right to enforcement cannot be implemented. Suspension emergency के टाइम पे है ना कि other rights cannot be, you cannot approach to the court if it is violated except Article 20 and 21. Now write Article 32 confers Article 32 confers fundamental right on individual. Article 32 confers fundamental right on the individual and obligation on the Supreme Court and High Court, and obligation on High Court and Supreme Court that it must discharge its duty, if fundamental rights are violated. Article 32 gives fundamental right to the individual but obligation to the Supreme Court and High Court that it must discharge its duty. Who? Supreme Court and High Court must discharge its duty when the fundamental right is violated, whenever or wherever it is violated. Fine. Have you noted down Harsh, Bishyajyoti, Aman, Nitin, Amber, Daman, Firnaj? Done? Okay. Yeah. Discretion मतलब नहीं भी कर सकता है, ऐसा नहीं है. If rights are violated, then it is obligation on High Court and Supreme Court. But first, when right is violated, where you should approach first, Supreme Court or High Court? This is the question. Any state. For example, your rights is violated in Kerala or somewhere in Delhi. Where do you approach? High Court or Supreme Court? You can approach to any court. one can approach to any court. There is no such classification. One should, but the Supreme Court judgment has given that if first the aggrieved person should reach to the respective High Court, okay, and then come to the Supreme Court. Fine. Otherwise, original constitution में ऐसा कुछ भी नहीं है कि whether you first approach to the High Court or the Supreme Court. But the Supreme Court judgment made it clear that one should reach first to the High Court, then to the Supreme Court. And there is no discretion of the Supreme Court whether it will entertain writ jurisdiction. It's a duty of the Supreme Court, the High Court. It's a duty of the High Court. The judiciary has two duty, the major duty, or three I say. One is to protect the Constitution. It is a guardian of the Indian Constitution. Secondly, to interpret the Constitution, right? And resolve the disputes between center and state. Third is to protect the rights of the people. तीन ही चार तो काम है ओरिजिनल, वो भी एक काम छोड़ लोगे, डिस्क्रिप्शन हो जाएगा, कैसे होगा? Why judiciary does not defined as a state under Article 12? Because it has to protect the rights of the people, right? Encroached by the state. That's why it is not a state. Fine. ऐसा पढ़ा है क्या कुछ? मुझे बताना, जब मेरे लिए अभी तक यही रखो, फिर दिखाना मुझे लक्ष्मीकांत, फिर I'll tell you. Fine. Now move to different this writs. Where do we have borrowed these writs? One more एक और लाइन लिख लीजिए. The right, writs have been borrowed from UK. Writs have been borrowed from UK. उत्तराखंड मत ले लेना. मैं एक क्लास में पढ़ा रहा था, किसी ने बोला उत्तराखंड, मैंने बोला कि अच्छा पता है उत्तराखंड में सिविल सर्विसेज के, यूके में सिविल सर्विसेज का कितना पोस्ट आता है? You know what is the vacant post every year in UK for civil services? And what is the applicant number? Huh? I was talking about UK means United Kingdom, right? So I was talking about there is a 3,000 seats every year, and applicant is 30,000 only. Probably sir, मैं तो UK में I'll apply in UK. How will you apply in UK? I'm talking about United Kingdom. It's not about Uttarakhand. Otherwise उत्तराखंड में तो 5 साल में एक बार ही होता है ये एग्जाम. स्टेट पीसीएस का बुरा हाल है, राइट? यूपी में तो 2-3 साल पे हो जाता है, 2 साल पे. बिहार में 5 साल पे, राइट? उड़ीसा में 5 साल पे, सॉरी हिमाचल में हर साल होता है. गुड. पोस्टें कम होती, सीट्स कम होती है. हाँ ठीक है, but in few states it takes long time. Oh yes. Now write habeas corpus. Habeas corpus. का मतलब होता है to have the body of. मान लीजिए consider one person is detained, right, or missing. What will you do? You have to file habeas corpus. Or if some person's liberty is being restrained, you can file habeas corpus, right? So right, the court orders that the missing or arrested person, the court orders that the missing or arrested person should be presented before it. The courts orders that the missing or arrested person should be presented before it. The court also orders to set free an arrested person. The court also orders to set free the arrested person if the manner of arrest is unlawful. The court also orders to set free the arrested person if arrest is unlawful. Fine. यही मतलब होता है habeas corpus का. Now एक मूवी आई थी अभी अजय देवगन की हिंदी में केरला में. Yeah, what is that? Not जब हिम. साउथ इंडिया में नहीं, अजय देवगन गोवा की मूवी है, गोवा पे बेस्ड. दृश्यम, या दृश्यम. Have you watched it? So वो habeas corpus लगाता है, right? Have you heard about one student? His name was Najib. He was missed from JNU, right? So even the Delhi police searched it, right? The CBI searched it, and he was not found, right? So if any person goes missing, or if a person has been arrested, one can file habeas corpus, right? Got the idea? कोई भी अगर पुलिस अरेस्ट कर लेता है, you can go to the High Court and file habeas corpus. Fine, right? The salient features of habeas corpus. Salient features of habeas corpus. Okay, habeas corpus can be issued against public body or private body, both. The habeas corpus can be issued against public body or private body, both. Fine. The habeas corpus can be issued against public body as well as private body, both. It means कि लिखना मत, it means कि confinement कोई नहीं रख सकता against the individual will. Even no private organization has right to confine someone, right? कोई भी अगर मान लीजिए घर वाले ने भी अगर मान लो बांध के रख लिया, one can reach to the phone कर देना, अरे habeas corpus अप्लाई करो. हाँ, कोर्ट विल इशू होता है. अभी एक केस आया था कि मदर फादर पेरेंट ही नहीं जाने दे रहे इस लड़की को. लड़की के केस में ज्यादा होता है, right? Because लड़की, the girls, wanting to go somewhere, but the parent was not willing to allow them. Fine? उसने फाइल नहीं किया था, मैं बता रहा हूं कि फाइल कर सकते हैं आप, right? Anyway, look, it cannot be issued against following cases. Second one, it cannot be issued in following cases. First, if arrest or detention is legal, it cannot be issued in following cases. First, when arrest or detention is legal, Second, when the proceeding is going on, for the contempt of legislature, when the proceeding is going on for the contempt of legislature or the court. So contempt of court या contempt of legislature के केस में if you are arrested, this habeas corpus cannot be issued. Third, when the arrest warrant is issued by the competent court. When the arrest warrant is issued by the competent court. Fine, that is the, it means illegal नहीं हो सकता, legal detention हो सकता है, right? And in case of legal detention, right, whether it may be contempt of court or contempt of legislature, or the judiciary has attempted, क्या? हाँ लीजिए ना, देखिए, अच्छा कोई बात नहीं, दिखा दीजिए. Yeah, right, mandamus. Mandamus. It's called we command. Yeah, got the habeas corpus. Habeas corpus idea clear? Can you repeat the last point? Last point क्या लिखवाया था? If arrest warrant is issued by the competent court, habeas corpus cannot be issued. Athira, if arrest warrant is, लाइए तो, अब बैठिए आराम से. मैं बाद में देखूंगा इसको. हाँ, right. So, right, mandamus. Okay. The court issues mandamus. The court issues mandamus to the public official. The court issues mandamus to the public official, asking him to perform his duty. The court issued mandamus to the public official, asking him to perform his duty that he failed or refused to perform. The court issued mandamus to the public official, asking him to perform his duty that he has failed or refused to perform. What happens when you go to the office, right? Office एक game आया था, serial आया था, पंकज कपूर का, right? What happens when you go office and public official does not perform his assigned duty? In that case, you can go to the court if your fundamental right is violated, right? What court will issue? Court will issue the mandamus and ask that official to perform his duty. वैसा ऐसा है तो थर्ड गवर्नमेंट ऑफिशियल का अगेंस्ट ये केस लगाएगा. Vaisak, I didn't get your query. If fundamental right, yes. Yes, yes. If your fundamental right is violated because some public official failed to perform some duty, right, you can go to the court will issue mandamus. बट ऐसा नहीं है कि आप डीडी ऑफिस में गए, आपको फाइल चाहिए था, डीडी ऑफिस ने फाइल नहीं दिया और यू कैन से कि माय राइट इज वायलेटेड. नो, योर फंडामेंटल राइट फ्रॉम आर्टिकल 14 से लेके आर्टिकल 30 तक. व्हाट आइडिया? फॉर एग्जाम्पल राइट टू इंफॉर्मेशन लीगल राइट में नहीं हो सकता. फॉर एग्जाम्पल आरटीआई के केस में आप नहीं जा सकते. नो, for the enforcement of legal right you cannot approach to the court, but for the enforcement of fundamental right you can approach to the court. ठीक है वैशाख? Fine. Now write salient features. Write salient features. Right, it cannot be issued against private body. It cannot be issued against private body. Right. Secondly, it cannot be issued. It cannot be issued to any department. It cannot be issued to any department when the duty is discretionary in nature. It cannot be issued to any department when duty is in discretionary in nature, कि वो करेगा या नहीं करेगा उसके मन पे है. In that case one cannot approach the court. It cannot be issued to enforce contractual obligation. It cannot be issued to enforce contractual obligation. It cannot be issued to enforce contractual obligation. It cannot be issued against the president, governor, and Supreme Court, High Court judges. It cannot be issued against president, governor, Supreme Court, and High Court governor, High Court judges. That is a mandamus. Now come to the prohibition. Prohibition. Meaning is to forbid. Meaning is to forbid. Right. It is issued by the higher court. It is issued by the higher court to the tribunal or lower court. It is issued by the higher court to the tribunal or lower court to prevent later it is issued by the higher court. Higher court means Supreme Court can issue the tribunal and High Court. It is issued by the higher court to the tribunal or lower court to prevent later from exceeding its jurisdiction. From exceeding its jurisdiction. It is issued by the higher court to the tribunal or lower courts to prevent later from exceeding its jurisdiction. Fine. Now write salient features. It can be issued only against judicial and quasi-judicial authority. It can be issued only against judicial and quasi-judicial body. It can be issued only against judicial and quasi-judicial body. Second, it cannot be issued against administrative. It cannot be issued against administrative or legislative body. It cannot be issued against administrative and legislative body. Now come to certiorari. To be certified. Meaning is to be certified. The literal meaning is certiorari. To be certified. First point you write. It is issued by the higher court to the tribunal or lower court. Quasi-judicial body means, for example, Finance Commission is a quasi-judicial body. Election Commission is a quasi-judicial body, right? It can decide some disputes. Okay, Amber. Recently, I think Supreme Court has given power to the Election Commission to decide about the fate of Shiv Sena. Who is the final owner of Shiv Sena? The Shinde group or the Uddhav group? Right? So election commission is a quasi-judicial body. Financial commission is a quasi-judicial body. Fine? Yeah. Kalika. It is issued by the higher court or to the lower court or tribunal, either to transfer. It is issued by the higher court to the lower court or tribunal, either to transfer or to squash the order. It is issued by the higher court to the lower court or tribunal, either to transfer or to squash the order of later. ठीक है, चाहे केस तुम अपना केस मुझे मेरे पास दे दो या खत्म करो इस केस को. Right, salient features. Salient features, right? It is issued on the ground of access of jurisdiction. It is issued on the ground of access of jurisdiction. It is issued on the ground of excess of jurisdiction or lack of jurisdiction. Or error in law. It is issued on the ground of excess of jurisdiction or lack of jurisdiction or error in law. It can be issued against judicial and quasi-judicial authority. It can be issued against judicial and quasi-judicial authority. And it can also be issued against administrative body. It cannot against. It cannot be issued against administrative body. Not लगा दो. It cannot be issued against administrative body. Certiorari. Oh. It can. Actually, Supreme Court का judgment है, मैं किताब पढ़ रहा हूँ. Right. Final है. It can be issued against administrative body. This is Supreme Court final judgment. It can be issued. Right. I'm just cursory look on the book. एक जगह लिखा है it cannot be issued. एक जगह फिर लिखा है Supreme Court verdict came. It can be issued against administrative body. हाँ. Right. देखिए. Third point, like prohibition, statutory cannot be issued against legislative body and private body. Like prohibition, statutory cannot be issued against legislative body and private body. Got the idea? How many writs we have studied? 4. एक note लिख लीजिए यहाँ पर. Write note. देखिए, all the above writs can be filed in the court. All of the writs discussed above can be filed in the court by the aggrieved party. All the above 4 writs can be filed by the aggrieved party. कि मान लीजिए मेरे साथ हुआ है तो मैं ही फाइल कर सकता हूं, ठीक है, दूसरा कोई और नहीं फाइल सकता. All above 4 writs can be filed in the court by the aggrieved party. All the above 4 writs can be filed in the court by the aggrieved party. Got the idea? Making sense? All the above 4 writs can only be filed in the court by the aggrieved party. जिसके साथ हुआ है वही कर सकता है, तीसरा नहीं कर सकता. लिखिए, but co warranto can be filed by any citizen. Last point से पहले, which writ can be filed in SC directly? That is co warranto. You know, co warranto can be filed by any citizen. And any of writs you can file in the High Court first, then the Supreme Court. Hers. PIL is something different. Writ is something different. Daman, PIL is something different. Writ is something different. Fine. The last point से पहले वाला point, यार last point से पहले वाला point बोला था मैंने. Like prohibition, statutory cannot be issued against legislative body and private body. Right? उसके बाद मैंने बोला all the above 4 writs can be filed by the aggrieved party, but co warranto can be filed by any citizen. Right? Co warranto. Co warranto. By what authority? Meaning is, by what authority? Right point. It is issued by the court. It is issued by the court to inquire. It is issued by the court to inquire into the legality of claim. It is issued by the court to inquire इंक्वायरी में आई होगा, आई वाला इंक्वायरी, नॉट ई वाला. Right? It is issued by the court to inquire into the legality of claim. Legality of claim of a person as a public official. अब क्या होता है, यू नो देयर आर, अब तो कम होता है, पहले क्या होता था, लोग सब इंस्पेक्टर बन के घूम रहे हैं, राइट, एंड दे आर एक्सटॉर्टिंग मनी, और सीबीआई बन के घूम रहे. कौन जी, हम, आई एम फ्रॉम सीबीआई, राइट. सो someone may claim that I am a CBI, but in that case, any person can file to the quo warranto in the court and check the legality of the claim of that person. Special 36, yes, legality of claim as a public office. क्या है 26, स्पेशल 26 मूवी मैंने नहीं देखी है, उसमें भी यही है. ओके, money. Okay. So if you remember, actually this is based on real life. He does dwivedi. Those in Mumbai, their whole they had this whole big website was voted by these people and they tested and CBI options. Oh. Yeah. Tiruvanda's name is away. Sorry. Tiruvanda's name is away. Those that is a very big brand. So they were. Fine, fine. Anyway, so एक salient feature लिख लीजिए. It prevents illegal claim of public official. It prevents illegal claim of public official by a person. Yes, 26 है, कोई दिक्कत नहीं है. It prevents the illegal claim, the claim of a public official. Now, next class, we are going to talk about DPSP, right? What do you need to do? You need to make a table for each article. अपने आप से बना लेना है, और टेबल के नीचे, मतलब टेबल के wherever you study ना, tables, study table, in front of a study table you have to just stick. What you have to do for each article, for example article 37, right, write just in a very one line, just summary of that article. Article 36, 38, 39, right, so that you can remember. 2-4 दिन पढ़ोगे तो कुछ कुछ याद रहेगा, right? It will help you in clicking basic in the PT, right? Even mains में भी you can quote article कि this article is this, right? नहीं, कुछ ऐसा आता है जो आप डिसीजन वहां पे डिसाइड करना है. फॉर एग्जाम्पल, मिनिमाइजिंग वेल्थ इनइक्वालिटी इज मेंशन्ड इन, अब वो दे देगा फंडामेंटल राइट, डीपीएसपी, ये वो. नाउ यू हैव टू पिक अप. नाउ अभी डीपीएसपी आपको लग रहा है कि डीपीएसपी, उस वक्त ध्यान में नहीं आता है, राइट, जब एग्जामिनेशन हॉल का प्रेशर अलग होता है. फाइन. So yes, the salient feature of each article, you can just summarize article in one line. हाँ, उसमें भी ABC है तो A में एक लाइन, B में एक लाइन, C में एक लाइन. क्या मतलब है? अगर वो याद रखना जरूरी है उसको, it's up to you, right? Otherwise, I'll tell you the basic features. What does it mean? What is the difference between fundamental right and DPSP, right? What are the amendments, in the important amendments within the DPSP, and what are the judgment, right? and what are the controversy between fundamental right and DPSP. Legality of a person, of an official, umber. Salient features means यार important. Salient का मतलब होता है important. इसके लिए अलग वर्ड यूज किया जाता है. एक है indispensable. I don't use the word. वो भी वर्ड यूज होता है इसी के लिए, इंपॉर्टेंट के लिए. ठीक है नितिन. सैलिएंट मतलब इंपॉर्टेंट, फीचर्स मतलब कैरेक्टरिस्टिक्स, फीचर्स मतलब कैरेक्टरिस्टिक्स. फाइन. So I'll stop here. See you on Monday.